A unanimous Supreme Court decision is one of the rarest events in American constitutional history, and when it happens, it is never because the question is easy or the stakes are small. It happens because something has gone so badly wrong for so long that even the most ideologically fractured court in generations feels compelled to lock arms and speak with a single, unmistakable voice. And that is exactly what unfolded in the opening days of January 2026, when all 9 justices of the United States Supreme Court, originalists, textualists, pragmatists, liberals, conservatives, jurists who routinely tear each other apart in blistering dissents, set aside every philosophical weapon and delivered a 9-0 ruling that detonated quietly but decisively across the American legal system. A ruling that does not merely reinterpret doctrine, but redraws the balance between state power and individual liberty, reshapes police accountability nationwide, and fundamentally redefines how the Fourth Amendment is applied in the real world, because in an era where 5-4 decisions dominate headlines and Supreme Court opinions increasingly read like partisan manifestos, a unanimous ruling sends a far darker and more urgent signal. It tells us the court believes the law drifted too far, too dangerously, and for too long, and that if it did not intervene now, the Constitution itself risked becoming a regional suggestion rather than a national guarantee. And if you are not already subscribed, you should be. Because what the court just did effectively closed a legal escape hatch that shielded questionable government conduct for decades. A loophole so powerful it did not merely influence outcomes. It determined whether justice existed at all based on nothing more than geography. A loophole that meant your constitutional rights were stronger or weaker depending on which federal circuit happened to control your zip code. And that loophole had a name that most Americans never heard until it was buried for good: the so-called moment of threat doctrine. A doctrine that survived quietly in appellate opinions, law review footnotes, and procedural dismissals until the violent death of a young man named Ashton Barnes forced the court's hand, because for years something deeply disturbing had been unfolding behind the scenes of the federal judiciary, not on cable panels, not in campaign speeches, but in dry appellate rulings that never make the evening news, rulings whose consequences were not abstract but permanent, life-altering, and sometimes fatal. Because imagine 2 identical police encounters, same facts, same decisions, same escalation, same use of force, same outcome, one in California, the other in Texas, and before this ruling, those encounters could receive completely different constitutional treatment, not because the Constitution changed, but because the courts did. Because prior to January 2026, your Fourth Amendment protections, the right to be free from unreasonable searches and seizures, were not universal. They were regional, fractured, and conditional, and that fact alone should stop every American cold. Because the Constitution is supposed to mean the same thing in Maine as it does in Texas, in Washington as it does in Florida, equal protection under the law is not supposed to hinge on which courthouse door you walk through or which appellate judges dominate your circuit. Yet that is exactly what had become normalized across much of the country, with most federal courts applying the long-standing totality of the circumstances test, evaluating police conduct by examining the entire chain of events, why the stop occurred, how officers behaved, whether their own tactics escalated the situation, whether safer alternatives existed, whether de-escalation training was ignored. A framework rooted in decades of Supreme Court precedent and consistent with Fourth Amendment history since the founding, but in a handful of powerful circuits, the Fifth, Fourth, Second, and Eighth, a radically different rule took hold, one so narrow it bordered on legal absurdity: the moment of threat doctrine, which instructed judges to put on what Justice Elena Kagan would later call chronological blinders, treating everything that happened before the final seconds of a use-of-force incident as legally irrelevant. Policy violations did not matter. Reckless tactics did not matter. Escalation did not matter. Ignored de-escalation training did not matter. The only question courts were allowed to ask was whether, in the final 1 or 2 seconds, the officer perceived a threat, and if the answer was yes, the analysis often ended immediately. Qualified immunity applied. The case was dismissed, often before discovery, often before trial, often before a jury ever heard a single fact. Accountability evaporated, justice became geographic, and if excessive force occurred in Houston, your case was often dead on arrival, while the exact same conduct in Los Angeles might still reach a courtroom, and this was not theoretical. The numbers were staggering. Between 2018 and 2023, federal appellate courts issued more than 240 published opinions wrestling with this constitutional fracture, disagreeing with one another nearly 60% of the time. More than half the time, federal judges reviewing similar facts could not even agree on the analytical framework governing the same Fourth Amendment claim. And that is not healthy judicial debate. That is constitutional chaos. Even more disturbing, the federal government exploited the confusion, taking opposite constitutional positions depending on which circuit it was arguing in. One interpretation in the Fifth Circuit, the exact opposite in the Seventh. Same constitution, same government, different answers, with ordinary citizens absorbing the damage until everything changed because of what should have been an unremarkable traffic stop in Texas lasting less than 2 minutes. Because in a case that now anchors constitutional law nationwide, Ashton Barnes was pulled over in Harris County for a minor toll violation, a few $100s in unpaid tolls, something that should have ended with a citation or a warning, but instead, within moments, Deputy Constable Roberto Felix unholstered his weapon, then made a decision law enforcement experts later described as tactically reckless, jumping onto the door of Barnes's moving vehicle and seconds later firing 2 shots through the window, killing Barnes over a toll violation. And when Barnes's family sought accountability, they ran directly into the moment of threat doctrine. Lower courts ignored nearly everything that mattered. They did not examine why the stop escalated. They did not examine the decision to jump onto a moving car, a maneuver widely discouraged by police training manuals nationwide. They did not examine whether de-escalation or disengagement was possible. They focused only on the final seconds because Felix was in danger at that precise moment, a danger created by his own tactical choices, and the court ruled the killing reasonable under the Fourth Amendment. Case dismissed. No trial, no jury, no accountability. And here is the point where the Supreme Court finally said enough. Because the truth is that getting a case in front of the court is almost impossible, not in theory, but in cold numbers, with roughly 7,000 to 8,000 petitions filed every year and fewer than 80 granted review, which translates to an acceptance rate hovering around 1%, meaning most cases, no matter how serious, no matter how unjust, no matter how nationally important, never even make it onto the docket. But Barnes versus Felix broke through that wall for a reason that went far beyond one tragedy, because it exposed a nationwide constitutional rupture that had been widening in silence, a fracture where fundamental rights were being applied unevenly depending on geography, and where the same Fourth Amendment claim could be treated as viable in one region and effectively dead in another. Not because the facts changed, not because the Constitution changed, but because the legal lens changed. Circuit by circuit, courthouse by courthouse, judge by judge, and the right at issue was not obscure, not technical, not some narrow procedural dispute. It was the Fourth Amendment itself, one of the core protections against government overreach and arbitrary force, a protection that is supposed to travel with you across state lines and not dissolve the moment you cross into a different federal circuit. And yet that is exactly what had been happening, because in certain jurisdictions the so-called moment of threat doctrine had been allowed to harden into a shield, a legal shortcut that encouraged courts to ignore the full reality of an encounter and focus only on the last instant, the last heartbeat, the last second or two, as if the events leading up to that moment were irrelevant. And Barnes v. Felix forced the court to confront how dangerous that approach had become, because it did not simply affect outcomes. It shaped whether accountability could even be tested, whether discovery could ever happen, whether a jury could ever weigh the facts. whether a family could ever get a day in court. And that is why the case drew a wave of amicus briefs, more than 40, from across the ideological spectrum: libertarian legal organizations, progressive civil rights advocates, former prosecutors, former law enforcement leaders, scholars of constitutional history, groups that almost never sign on to the same message agreeing on this one point through very different pathways: that the moment of threat doctrine was constitutionally indefensible, not just flawed, but structurally incompatible with how the Fourth Amendment has been understood for generations. And when oral argument arrived in early January 2026, the court's skepticism was immediate, pointed, and notably bipartisan, because the justices were not treating this as a niche dispute. They were treating it as an institutional problem that had metastasized. And Justice Elena Kagan posed the question that effectively shattered the government's position by exposing the doctrine's moral and logical core, asking, in essence, whether an officer could provoke a confrontation, manufacture danger through reckless tactics, drive the encounter into a crisis, and then invoke that self-created danger as legal justification in the final seconds, a question the government struggled to answer cleanly because any direct answer risked admitting the doctrine's most alarming implication, that it could reward escalation and turn accountability into a disappearing act. And while the government searched for footing, Justice Neil Gorsuch pressed the historical point with a different blade, reminding everyone that the Constitution had not changed, that the framers did not evaluate government power through isolated snapshots, and that the Fourth Amendment was never meant to be read like a freeze frame. So why should modern courts pretend that context does not exist? Why should courts behave as if everything leading up to a fatal moment vanishes from constitutional relevance? And then, when the decision arrived days later, the message was devastatingly clear, written by Justice Kagan for a unanimous court, declaring that a court cannot possibly claim to evaluate the totality of the circumstances while wearing chronological blinders, because blinders are designed to block vision, not clarify it. And the court's reasoning landed with a simplicity that made the doctrine look absurd in retrospect, explaining that you cannot understand a movie by watching only its last frame, and you cannot honestly understand a story by reading only its final sentence, because the ending is shaped by everything that came before it. And from now on, courts must examine the entire sequence of decisions from start to finish, meaning the constitutional analysis must include the lead-up, the tactics, the choices, the escalation, the available alternatives, the missed chances to de-escalate, and the ways an officer's own decisions may have created or intensified the danger, holding officers accountable not only for the force they use, but for how and why they arrived at the moment they claim demanded that force. And the impact of that shift is not theoretical, because while the ruling does not abolish qualified immunity outright, it makes it significantly harder to weaponize as a shortcut to dismissal, significantly harder to slam the courthouse door before evidence is gathered, before depositions happen, before jurors hear what really unfolded. And that is why the shockwaves are already moving outward, pushing departments to rewrite training manuals, forcing administrators to treat de-escalation not as optional best practice, but as constitutional expectation, driving cities to reevaluate closed cases and pending claims, rattling municipal insurers who price risk based on legal exposure, and igniting furious debate between law enforcement unions demanding protection and civil liberties groups demanding reform, with the temperature rising precisely because this ruling removes a convenient escape route. And what made it even more explosive is what the court did not do. There were no dissents, no concurrences, no hedging language, no separate opinions trying to soften the blow or carve out a back door. Every justice signed on fully, which is the institutional equivalent of a red stamp across the doctrine itself, the court declaring in unmistakable terms that the moment of threat defense is DA. Here is the question you need to consider right now. Will lower courts honor the spirit of this ruling? Or will they quietly attempt to hollow it out through narrow application and procedural gamesmanship? Because the Supreme Court has made one thing crystal clear: context matters, history matters, and constitutional rights do not begin in the final 2 seconds. And now we want to hear from you. Do you believe this ruling finally restores balance between state power and individual liberty, or will entrenched institutions find a way to resist it? And at the end of the day, does a unanimous Supreme Court decision still have the power to force real change in America, or has the battle merely shifted to a new front?